And good morning, everybody. This is Vinny Maletti with Maletti Law, the strongest name in law. The day is Monday, January 21st, 2022. It is about 10 o'clock in the morning. It is a very cold day here in Brooklyn, New York. So certainly, hopefully you're indoors and you're not braving any of this weather because you have nothing to prove to nobody. Okay, so let's get down to it. So first and foremost, please do click on the subscribe button below. Please do go to the website, www.malettilaw.com, and subscribe to the newsletter. This way, so you're in the know of all the updates and everything that's going on. Always trying to deliver new content. We have a lot of things going on at all times, including, podcasts that we're sending out, emails, strategic notes, legal advice, updates, all kinds of stuff. So certainly don't miss out on anything, and please make sure to go to subscribe to the channel and sign up for the newsletter. Okay, so I thought this video would be very helpful for everybody. So a lot of these come in and have questions on what are the minimum requirements, or how do I have a case? Do I have a case, right? Obviously, all these aren't attorneys, right? So this kind of stuff's not like readily familiar to you. It's not kind of in your face. So I usually give out like a questionnaire to people, but I'm wondering if the questionnaire is very long and people aren't reading it, or if just I happen to be very long-winded when I write, just like when I speak. So I'm just wondering if that's something that's been deterring people. So I'm hoping that this video can kind of like give you a walkthrough to determine whether or not you legitimately have a case for discrimination or harassment or retaliation. This video will explain the basic preliminary minimum requirements needed before you could file a claim. So this video is very helpful for you. If you feel you do have a claim, you should be able to check off any of the boxes in this video that I'm going to describe. And if that's the case, then certainly, we should move forward to it. You get on a retainer. I'll give you full disclosures to fees and everything, and, assess what your risk is. But for the most part, though, these are the basic bare minimum requirements needed in order to determine whether or not you have a claim for discrimination. And yes, this is Flex, the fuzziest name in law, who makes it a point to always interrupt me and always ask for attention when I'm speaking on videos, no matter what, because this is his favorite thing to do, is to bother Daddy. Okay, so let's get down to it. So, the first question is going to be, what kind of discrimination did you suffer? So remember, discrimination needs to be more than something that's just a one-time act. Harassment, all these things need to be more than just one-time event, right? So like Bob comes in and says something crazy to you. Though it's, it is harassing and it is discriminatory, it's not at a legal standard, something that's actionable. So, keep in mind you want to have a couple of these things, these discriminatory acts. So check out a few of these boxes. If you fall into one of these, this is your starting point. So, did you suffer from discriminatory acts? So the most common ones in New York are going to be they refused to hire you. They gave you a disciplinary notice or a negative performance review that was improper. They denied a request for accommodation, maybe based on your disability, your pregnancy-related condition, or maybe your religion. You were sexually harassed. Sexual doesn't mean you were physically sexually harassed, but rather comments based on your gender or sexual preference. You were denied an accommodation for domestic violence, let's say. Domestic violence is also a protected category now in New York. You were harassed or intimidated based on any of the protected categories which we will go into. You were demoted. They had a layoff. They didn't call you back after the layoff for some unusual reason. They denied you an accommodation in any other event, specific religious practices. You need to take that week off for something in particular for, your Jewish faith, let's just say, because I think they have a different calendar. So that could be the basis of it. They denied you services, or you were treated differently from other employees as they would have treated other employees. They denied you a promotion. They denied you a pay raise. They paid you a lower salary than other coworkers who were performing the same job. They denied you leave time or some other benefits that would have granted others. They denied you licensing. They denied you training. They gave you, different or worse job duties than other workers who do the same job. They had some kind of discriminatory query into your job application or your promotional application. Let's say they asked an excessive amount of questions about your disability, which they're saying was a prerequisite to get the next job. So that's a big problem. And then also, there are others, but these are generally the most common So in this video, I'm going to try to edit this video to make sure you have like a list. So hopefully that these lists are popping up. Otherwise, look in the comments below and you'll see everything. Okay, so the second question, remember the first question is what discriminatory act did you suffer? The second question is what protected class are you a member of? Because the discriminatory acts have to be based on some kind of discrimination against a protected class. So New York has a lot more categories than the federal government does. Most of you will fall within the ambit of the federal government, but New York does offer a lot more. New York offers some kind of like silly ones, but whatever, New York is New York and it's special. So your protected classes are going to be age, if you're over 40, your alienage or your citizenship status, your arrest record, your military status, your conviction record, domestic violence victim status, your pregnancy-related condition status, your status as someone who needs a guide dog, hearing dog, or a service dog. That's a new one. I didn't see that a week before in the regulations. I guess they're taking it more seriously now because of, I guess COVID and more people have pets. Predisposed related conditions. This really is going to go to your genetic identification markers. We'll, touch that a little bit. Your skin color, your creed and religion. So this could be your mainstream religions. This could be your, Catholic, Judaism, Muslim, or it could even be some of the unusual ones that you see a lot, like the flying spaghetti monster. Yeah, that's what we are, flying spaghetti monster. It's real. Your disability or perceived disability, your family status, your gender identity or expression, transgender, feel like a man, feel like a woman, can't be discriminated against in New York. Your lawful occupation or lack thereof. So this is an interesting one. If you are unemployed for a certain amount of time, your employer asks you a multitude of questions about your unemployment and then makes the decision to not hire you based on your unemployment status. That's illegal. Where you get your lawful sources of income, your marital status, your national origin, your partnership status, which is New York's way of saying if you're involved in a same-sex marriage or something to that effect, your race or your sexual orientation. So those are your protected categories. So you have to protected categories, protected classes. So the discriminatory act has to be based on their frustration with one of those protected classes that you happen to identify with. If it's retaliation is a little bit different. Retaliation follows a little bit different model. With retaliation, you need to show how you were treated differently after you've either filed or helped someone file or participated as a witness, or otherwise you have taken an act that you perceive is lawful, that you perceived was the right, that you believe genuinely was lawful and was the right thing to do. You have taken that action and you have been treated in a retaliatory manner. You have suffered a detriment in retaliation because of your lawful or what you perceived to be lawful act. So in other words, you see your employer doing something naughty. Your employer is actively sitting there and shredding tax documents to be able to screw the federal government out of tax money. You think this is a legitimate wrongful act. You say you report this, and then they terminate you in retaliation. That's legit. That's a fight. You could fight over that. That's a legitimate argument. Whether or not, you make a fortune on it's not a different story, but that's still, you meet the minimum requirements at that point, you could bring a retaliation claim. It's certainly much stronger when the retaliation is based on some kind of animus toward one of those protected categories, but retaliation is kind of like this very broad category that encompasses a lot, and you could find a lot of claims and you could find a lot of damages within the category of retaliation. Couple of odds and ends questions. So one, did you report or complain about the discriminatory treatment to your supervisor or to whoever is above you? That is kind of like, that must be done. So the statute's not going to outright say it, but that is like something that must be done. So always keep that in mind. You must have went up the chain and formally reported this to somebody. Another very helpful yes or no, which you hope yes is the answer. Do you know others who are treated either the same as you or better than you or just as bad as you? That's going to be a critical question because, when it comes to discrimination and how you've been treated, the first thing they're going to do is do comparatives of similarly situated individuals. You're saying that you would say, let's say you're a black female I was discriminated against because I was a black female. They're going to look at black males and see how black males are treated. They're going to look at white males and white females, see how white males and white females are treated. If you were the only one treated in that way and you qualify as a black female, then you've hit the jackpot. So keep that in mind. They're always going to want to know whether similarly situated people were treated the same as you, or treated different than you, or whatever the case is. So those are your 2 yes or no questions. You hopefully can answer yes to each of those. So yes to whether you've complained to a supervisor, and yes whether you know of people that were either treated differently, better, or worse, or something you could explain. Okay, so 4th, again, this is another one that's not in the statute, but just because I've had a bajillion of these claims and cases, you're going to want to have this: 2 witnesses that have either seen or heard the discriminatory treatment. At least 2 witnesses that could support your case, that could testify and support your case, and have had visual, observance of it. So, for instance, again, you say you were discriminated against for, you're an African American woman, and you were discriminated against. They treated white women better than you. And you have 2 witnesses that have seen. Let's say on one day your boss comes in with donuts. Here you go, Pam, here's your donut. White woman, here you go, Beth, here's your donut. White woman, oh, Shaquana, we have no more donuts for you. Sorry, no donuts. Shaquana doesn't have any donuts. Andrea, you have donuts in the back as a white woman. You're number 3. Those 2 are your witnesses, So, this is obviously a stupid example, but whatever. I'm just trying to convey the message out in an easy way for my people. All right, so the final question you're going to want to ask is, what are your expectations by way of settlement, right? So, everybody wants their day in court. Everybody wants to sue for $1 million and go to trial and fight and be heard. Everybody wants this, right? Most of you won't get there. And not because your cases stink, but because everybody wants to settle. Nobody wants to spend that money. It's going to cost a defense attorney $300,000, $400,000 to defend their claims. So, at the end of the day, you need to come up with some expectation. If you're offered, at what point, how do you want to resolve this, right? It could be payment for the time you've already missed. It could be payment for time going forward. It could be payment for the emotional distress you've suffered. It could be reinstatement. You might not even want to continue fighting. You just might want to go back to work. It could be a promise that the harassment's going to stop. It could be a letter of apology, which you're probably better off. You'll probably get $1 million before you'll get a letter of apology, in my experience. I've yet to see one letter of apology from any employer. I've now been involved in 1,100 cases in my lifetime. I'm going to be 40 years old. I've been involved in 1,100 cases. I've never seen a letter of apology in 1,100 cases. Just saying. Alternative employment, maybe employment in another position. That's another very, that's a very common thing, especially now in COVID, with everybody being remote. I have just almost been seeing endless amounts of offering restatements in remote positions. It's so much for employers that just makes more sense for a smart employer than paying you millions of dollars, or even paying $100,000 to their attorney to settle out with you. And then, there's like a little catch-all, right? Anything you could really think of. Some people, some people may want just benefits only. Some people want reinstatement. I don't know. What if you want to settle for a coupon? Who knows, right? But this is your right. You can settle for what you want to settle for. But just have a sense of what that is, because you very likely will not make it to trial because they'll want to settle you before. And everybody loves a good settlement. Especially judges. They love settlements. So that's generally what you need to know. The basic minimum requirements you need before you could bring these cases to really have a realistic chance. Because what you don't want is, you don't want to say, okay, I've suffered from a hostile work environment because maybe your boss was an asshole. Sure, your boss could be an asshole, but at the end of the day, that doesn't mean that they were legally liable for discrimination, right? So the law isn't gonna make sure that your boss is a nice employer. The law isn't going to serve as a moral compass for employers. Rather, the law is going to just prohibit what is against the law, and that is discriminatory treatment of people based on certain categories and classes, not being a jerk off. If your employer wants to be Scrooge and make you all work on Christmas, that's probably a bad idea, because you could probably get a religious discrimination claim against him. If your boss wants to be open on Christmas, and you want somebody to work on Christmas, it's fine. You can't sue him for that, you know? If your boss just happens to be very nasty and wants a response in 24 hours to his emails or her emails, that's okay. Your boss could be a jerk like that. You want that. There's no problem. If your boss doesn't want to let your dog come into the office because your dog is a pain and distracts everybody and ruins every single video because he wants attention, if your boss, if that's your boss, whatever, not discriminatory. If your boss wants to tie the dog up with duct tape somewhere, that's all. So look, I hope this video was helpful. Certainly if you've been aggrieved, call the office, set up an appointment. If you can answer these questions, we can go ahead and take your case. I just want to be very clear, and I want everybody to understand that there are certain minimum legal requirements that you need to get there, to even open up the front door. And, you're already in a position, where you don't have a fortune to spend, right? So you want to make sure that you at least, you at least make something with your money. You have a reasonable expectation of at least your money goes to someone to a fighting shot. And, at the end of the day, that's really what you want. Because you really want your day in court. You want your voice to be heard. And, you don't want to be begging for affection like this guy over here. Look at how much he bites. So, look, listen, obviously, everything's, email us if you need any information. If you'd like a copy of this questionnaire, that maybe might help because I do speak fast. I'm going to try to edit this video to have everything. That's why I'm like standing on the left. This is my left side of the video, so you can see here. Like, I'm hoping everything's popping up. If it doesn't, I'm sorry. It's YouTube editors, But you can email us, and I'll certainly give you all the questionnaires. You can determine if if you meet the minimum requirements to bring a case in. So, without much further ado, I hope you have a beautiful day. Stay warm. It's freezing out there. The snow is terrible. Your car is likely buried. Probably not going to be unburied till about Wednesday. It's on Monday, so you got some time. So, enjoy your time. Take it easy one step at a time today. You're probably working remote from home. And obviously, if you have any questions, concerns, want to ask us anything, we're always here. We're never far. Yours in loves, and lives. This is Vinny Maletti, the owner, founder, partner, God King of Maletti Law. Here to answer all your questions and help you all out. Have a great day.